Hey, my name is Sturgill. So I'm a legal aid attorney that works here in Charlotte, and I've been representing tenants in eviction court for about 10 years. And so what I wanted to do today was to talk to you a little bit about the eviction process and to talk about tenants' rights in North Carolina. One thing that we've seen over the last year or so, especially since COVID hit, is unfortunately an increased amount of evictions in our county. And let me give you a little bit of background on that. So one thing about Mecklenburg County is that even before COVID, our eviction rates in this county are about twice the national average. And so it's really sad, but even before COVID, the number of eviction cases that move through the court every year in this county are about 30,000 a year. And that's even gotten worse since COVID hit. There was a study back in July of this year that said that about 200,000 families were behind on their rent in North Carolina. In Mecklenburg County alone, it was about 24,000. And so I'm in eviction court pretty much every day during the week, and we've seen the courtrooms are packed right now. And it can be a really scary and really stressful experience for people that have never been through that before. And we're seeing a lot of families that are being evicted now that have never had to deal with that process before. And so what I wanted to do was just talk about the process, talk about some basic tenants' rights in North Carolina, and then also talk about some resources that are available for tenants in this state and in this county. And I hope that by doing this and by explaining the process, we can kind of help, put some knowledge out there and take some of the fear away and talk about some resources and what to do if you find yourself in this situation, or if if your sister, if your cousin, or if your friend finds themselves in that situation. So that's the purpose of today's presentation. Well, let's see if I can get it to switch here. Hold on. Well. There we go. Okay, so one thing I want people to realize is that being evicted is a really scary and stressful experience. Housing is a basic human right. And a lot of studies have shown, we talk about the housing first model, which means that healthcare, education, all of these other things suffer if you don't have a roof over your head and if you don't have stable housing. And that's been proved by a ton of studies. And so if you're a family that's renting a house, or if your friend or whomever gets their eviction court papers or finding themselves facing an eviction, it's earth-shattering, right? If you're about to lose the roof over your head, it can be really scary and it can be extremely stressful. And the eviction process is kind of complicated and it's really scary. There's a lot of different laws that apply. And so if you don't have an attorney and if you're having to represent yourself in eviction court, you may be at a disadvantage if you can't afford a lawyer and you're unaware of your basic legal rights. And so what I'm trying to do today is just explain some of those rights. Legal aid in North Carolina, we represent about 1,500 tenants a year. But again, there's about 30,000 cases. We're under-resourced, and it's hard to get an attorney if you can't afford one. One of the big things I want to explain right off the bat is that there's one legal way to evict a tenant in North Carolina, and that's through the court process. So if a landlord wants to evict a tenant, they can't just put their stuff out on the curb. They can't cut the power off. They can't cut the water off. They have to file a lawsuit. The tenant will receive court papers. There will be a trial. The tenant has the right to present any defenses that they have to tell their side of the story. And there has to be a court order. A judge has to decide that, yes, this landlord has the right to evict this tenant and enter a court order. And that's the only legal way that a landlord can evict a tenant. So anything other than that is illegal. So if a landlord, a lot of times tenants will get a letter from their landlord saying, we want to end your lease, or we want to evict you. And a lot of tenants that call us will have this fear that if the landlord tells them you have to be out by the end of this month, and they're not out by the end of the month, that on the first day of the next month, the landlord's going to be able to throw their stuff on the curb, change the locks without a court order, cut off their power, or do something else to try to throw them out. And that's not the case. So there is a process. They have to go through the legal process. The tenant does have rights. They have the right to a hearing. There's an appeal process that we're going to talk about later. And so it's not as fast as you think. And what we see, unfortunately, is a lot of tenants are unaware of that fact. And so they do something called self-evicting. So they get a letter from their landlord. The landlord's telling them to be out by a certain date. And they're so afraid that if they're not out by that date, even if there's issues going on, like maybe there's not repairs that have been done or other things they have against the landlord, they're afraid if I'm not out by this date, I'm going to have all my stuff thrown on the curb the next day. And so they self-evict. They say, I'm not familiar with the process. I'm scared. And I'm going to, move myself before the end of that, whatever date they tell them to be out because they don't understand the process. So that's a big picture thing. But I want people to understand that if you're a tenant, if you disagree with your landlord and you don't think your landlord has the right to evict you, if you self-evict, there's no process there. But if you stick to your guns, there's a process the landlord has to go through, and you have the right to be heard and to raise any defenses that you may have. And if a landlord, we call it self-help eviction, but if a landlord evicts a tenant without going through the court process, that is a huge no-no, right? That's awful. That's illegal. And if a landlord does that to a tenant without going through the court process, the tenant may have claims against the landlord and may be able to get, damages or money against the landlord. So kind of briefly, I want to talk about the eviction process itself. So we're talking about the legal process. So we know that the only legal way for a landlord to do it is to go through the court process. So let's talk about what that looks like, okay? An eviction lawsuit in North Carolina is called an action in summary ejectment. That's the legal terminology for an eviction lawsuit. And it's usually filed in small claims court. Let me say one thing about this. Typically, the process is very fast. It's called summary ejectment because it's summary meaning quickly, right? So one of the things about the law in North Carolina is that if a landlord files an eviction lawsuit against a tenant, the tenant may only get 2 or 3 days notice before their court date, which is ridiculous, right? Like, how are you supposed to get childcare set up? How are you supposed to get time off work? And this is kind of part of the nature of the machine where the tenants, they get served, they only have a couple days before their court date. And what you'll see during typical times is that sometimes the court will schedule over 200 eviction cases for a 1-hour docket. And you ask yourself, how could the court hear 200 cases in an hour? And they can't, right? But what they know is that because the process is so fast and because people can't make arrangements to be in court, if you have 200 cases on a docket, typically maybe only 10 to 15 tenants actually show up, right? Because the other 185 can't make arrangements to get there. And that's the state of the law. It's not fair and it's not good, but that's the way that the process works. I will say that with COVID and with restrictions on the courthouse as far as trying to keep people safe and prevent overcrowding, that process has slowed down a little bit right now. So now tenants usually get something between like 2 weeks to a month of notice beforehand. But during typical times, it's only a couple days. And so if a tenant gets served with eviction court papers, so if you're a tenant facing an eviction lawsuit, you're going to get at least two pieces of paper. You're going to get the complaint. That's the court paper that tells the tenant why the landlord thinks they have the right to evict the tenant. And then the summons, which is just basically telling the tenant when and where their court date is going to be. So this is the complaint. We see, thousands of these, a year, right? So this is the court paper that the landlord would fill out to start the eviction process. And up here where the red circle is, these are the different reasons why a landlord can evict a tenant. Non-payment of rent, if the lease term is ended. The most common one is the third one right here. So if the landlord is saying that the tenant broke some rule in the lease. And then the last one, which is very rare, is criminal activity. There's a special law for evicting tenants for criminal activity. And then the summons, this is what it looks like. The case number is up there. This will tell the tenant the date, the time of the trial, the location of the court and the courtroom. So one thing, a lot of tenants, when they get their court papers, if they have time to make a decision about should I go to court or not to try to defend myself, there's a couple of considerations there. There's a couple of things that a landlord can ask for in an eviction case. They can ask for something we call a possession judgment, meaning that the landlord is asking the court to order the tenant to be evicted and to give the property back to the landlord. And the landlord can also ask for a money judgment for any kind of unpaid rent or damages that they may be claiming in that situation. One kind of weird thing about North Carolina law is that if the landlord is asking both for the eviction and money, a money judgment for unpaid rent, and let me tell you this about a money judgment, if they get one, it stays on the books for a really long time and it builds interest, right? So if a landlord gets a money judgment against tenant, it's on the books, there's a legal record of that, and it gains interest at 8% until the tenant pays it off. But in North Carolina, a landlord can only get a money judgment if either the tenant shows up for court or the tenant was served personally with the court papers. Now, personal service means that the sheriff shows up, knocks on the door, some adult in the home answers the door, and they personally hand those papers to the tenant, right? So if the landlord serves the court papers that way, they can get a money judgment, or if if the tenant shows up for court, they can get a money judgment. However, another thing that's kind of unfair about the eviction process, in addition to the short time frame, is that landlords can serve the court papers by something called posting. So posting means they just tape a copy of the court papers on the door. That's considered valid service in North Carolina, only for eviction cases. So if the tenant's only served by posting, and if the tenant does not show up for court, the landlord can get the eviction judgment, but can't get the money judgment. And so sometimes tenants will decide, well, I've looked over my case. I can't identify any legal defense for the eviction. I was served by posting. Nobody handed it to an adult in the household personally. They just taped it on the door. And so in some rare situations, a tenant may decide it's actually better for me not to show up for court, because if I do, the landlord can not only get an eviction judgment against me, but also a money judgment. But if the tenant has a legal defense, and we're going to talk about some of those today, it's a better idea for the tenant to go to court, because if they're not in court, they cannot argue that legal defense to the landlord. Some general advice for tenants, to prepare for court. It's a good idea to read the complaint so the tenant understands why the landlord thinks they have the legal right to evict them. Sometimes tenants have counterclaims. So sometimes the tenant can also file a lawsuit against the landlord for certain things. And we're going to talk about that in a minute. But if the tenant wants to do that, they need to file those claims before court. The tenant should gather whatever evidence and witnesses they have, and practice what they'll say in court. It's always good to be prepared. One thing about eviction court in North Carolina, and especially in Mecklenburg County, is that the courtrooms are packed full of people. The judges don't have a lot of help. They have only maybe sometimes it's just the judge. There's no sheriff's deputies or anything, and so they have to do everything themselves. And so if you're going to go to eviction court and try to argue a defense or try to stop the eviction, the better organized and the better prepared you are, the better your chances are, because the judges are used to seeing people being unprepared. There's a short time frame. It's a lot of chaos, and so the more organized, the better. On the day of court, the tenant wants to show up on time. So again, if you have 200 cases on a 1-hour docket, a lot of time, I've actually seen before where tenants are maybe 10, 15 minutes late, their case is already over at that point. So it's really important to be on time. If the landlord tries to testify about things that they don't actually have personal knowledge about, so if the landlord is trying to say, oh, this person told me that, I heard this, I heard that, but that person is not actually in court, the tenant can object to that. That's called hearsay. When it's the tenant's turn, testify, show their evidence, stay calm. The judges don't have a lot of patience for arguing or that type of thing. And then to end the testimony by saying what they want. Most of the time, the tenant wants not to be evicted, right? So that's going to be what they're asking for, is for the case to be dismissed, so that the judgment's not entered against them. If you have a family member or a friend or whomever who is facing an eviction that's been served with court papers, we talked about a lot of times most of the tenants don't show up, or maybe they do show up and they lose, right? One thing that's really good in our eviction process, even though I don't like the short time frames, I don't like the way that they can be served, is that there is an appeal process. So if you know somebody, maybe they missed their eviction court date, right? Maybe they couldn't make arrangements to be there, or maybe they went and they lost. there is an appeal process. And so if the tenant has a judgment entered against them, they have 10 days after the judgment to file an appeal. And if the tenant files an appeal, they'll get a new court date. It'll be in front of a new judge. They get more time to prepare. So instead of a few days or whatever the case may be, it's typically 2 or 3 months. With COVID and all the delays in the court now, it's more like 4 or 5 or sometimes even 6 months at this point. And the tenant's also allowed to stay in their home while they're waiting on the appeal. The only caveat to that is if they lose and they file an appeal and they want to stay while they're waiting for their appeal, they have to pay something called a rent bond, which is essentially means that they have to start paying their rent as it comes due into the court. So they don't pay it to the landlord, they pay it to the court. But as long as they're making those rent payments into the court moving forward, there's nothing legally a landlord can do to evict them while they're waiting on their appeal. If a tenant does not appeal in time, or if the tenant appeals but doesn't make the bond payment on time, the landlord can file for something called a writ of possession. And what that is basically an order from the court telling the sheriff's department, go remove this person from the home and stand guard while the landlord changes the locks. If you have somebody that's had an eviction judgment entered against them, there's only 3 forms that they need to deal with to file their appeal. Legal aid, we help people do this all the time. I helped a client yesterday do this. There's a notice of appeal. There's normally a $150 filing fee for the appeal, but we have a fee waiver form called an indigency petition. So that means if you receive any kind of public benefits like food stamps, SSI, TAMF, anything like that, you can get the court to waive that filing cost. And there's also a rent bond form that the tenant will have to fill out, just explaining to the court what their rate of rent is, and that helps the clerk set the bond that we talked about. For tenants who don't file the indigency petition, they may have to pay their back rent into the court as a bond too. But if you qualify as indigent, you don't have to pay the back rent, you just have to pay the rent moving forward. And so that's a very powerful process for a lot of tenants because a lot of them miss their first court date. A lot of them may try to go to court without a lawyer and they may lose. But if they file these 3 forms, and if they do it in time, they can stop the eviction process, they can get a new court date, they get much more time to prepare, right? And there's nothing that the landlord can do in the meantime to kick them out. So that can extend the process from a couple of weeks to several months to now, with the restrictions with COVID, it could be half a year just by using this appeal process. And so if you have people in your life that that are going through this is a very powerful tool. So now the fun stuff. We're going to talk about some defenses to eviction first, and then we're going to talk about some resources for tenants after we talk about this. But there are several defenses that are very common in eviction proceedings. One has to do with eviction notice. One has to do with if you can pay the money before the court date. Repairs are a huge thing. So a lot of landlords don't make repairs when they should, and that may give the tenant a defense or even a counterclaim against the landlord. The Fair Housing Act we're going to talk about, that's a law that says that landlords cannot discriminate against tenants based on certain protected groups. And then we're going to talk about a couple of consumer protection laws. Tenants are consumers, landlords provide a service, and there are rules that govern that. Eviction notices, some leases require notice, some do not. Some waive notice. For non-payment of rent cases, sometimes notice is required. And just bear with me for a second. So if you have a verbal lease, an oral lease, or if you have a lease that does not have a provision in it that says that the landlord can terminate the lease if the tenant breaks a rule in the lease, what we call a default provision. There's a law that says before the landlord can evict, the landlord has to demand all the rent that's due and then wait 10 days before filing the eviction. So in those situations, if you have a verbal lease or oral lease, or if you have a written lease that does not have a sentence that, or a provision that says they can evict if the rule in the lease is broken, that 10-day notice requirement is there. And if the landlord doesn't do it, that's a defense. And before I go further, there's landlord-tenant law, there's a lot to it, and I don't expect everybody to remember everything that we talked about today, but I'm trying to help people do something called issue spotting, which is I hope you remember enough to where if you have a family member or a friend or somebody that's going through this situation, you might not remember the exact rules, but maybe it'll raise a red flag in your head. So I think I heard something like that, right? And then you can come back, refer them to legal aid, look at this presentation, come back to it, and that might help them empower themselves to fight the eviction. In that same situation, if it's a verbal lease, so if there's no written lease, or if there's not a written lease that has that default provision, the tenant also has the right to cure. And that means if the tenant can come up with the past due rent and the court cost before the judgment's entered, that the tenant can stop the eviction process just by offering to pay that to the landlord. And even if there is a written lease with a default provision in it, a lot of times if the tenant pays money after the landlord files the eviction notice or proceeds with the process, there's this concept called waiver, which means that, okay, the landlord said he wants to evict me, but the month after he said that, I offered rent and the landlord accepted it. And the law says in most situations that means that the landlord has given up their right to proceed and that they can't proceed at that point because they've decided to take the money instead of going forward with the eviction. There is a caveat to that. So some written leases allow the landlord to accept the rent and still pursue the eviction. You'll see it in a lease. It's called a non-waiver provision. And so it's very important to read your lease to see if there's something like that in there. This is always good advice. If a landlord agrees to, so let's say you've got an eviction notice and you offer to pay and the landlord agrees to take it, you may want to get that agreement in writing, right? Because what if the landlord accepts the rent and then tries to move forward with the eviction anyway? It's always a good idea to try to get that in writing and get the landlord to sign off on it. And I'll tell you, our courts, they don't like that. So if the landlords agree to it and they try to move forward anyway, that's a really easy defense that the tenant can bring up. There's this other rule. So for cases where the lease is expired, or if the landlord's claiming that the tenant broke a rule in the lease, the landlord also has to demand that the tenant get out before they file the lawsuit. And you'll be surprised at how often they forget to do that. This is another really common defense. So if the landlord, maybe the rent is late and the landlord doesn't send any notice at all, and maybe their lease doesn't require notice, but even if they're not having to give a termination notice, the landlord still has to tell the tenant to get out. They have to demand that the tenant leaves in those situations. And if the landlord forgets to do that or they don't prove that in court, that's another defense. This is one of the biggest things that I get the most questions about. And it comes up all the time. And you wouldn't believe the situations I've seen in Charlotte. We've seen rat infestations. We've seen mold. We've seen leaky pipes, unsafe electrical wiring. I had a client's house that caught on fire because of unsafe wiring. And so the question is, what's a landlord's duty or obligation as far as making repairs? And the laws in North Carolina are actually pretty strong on that. And so what the rule is that landlords have to do several things. They have to obey the local housing code. And in Charlotte, we actually have a really good housing code. It's very comprehensive. It covers a lot of different things. If a tenant's home needs fixing, the landlord has to fix it. It's that simple. And it doesn't matter what the lease says. So even if and I've seen this before, even if the landlord puts some rule in the lease that says that we're not responsible for repairs, we wash our hands, the tenants have to make all the repairs. I've seen weird stuff, like I've seen a lease that says that any repairs under $500, the lease has to repair, or the tenant has to repair it, stuff like that. It does not matter what the lease says. The lease can say whatever it wants to, and even if the tenant signs off on it, it doesn't matter. So no matter what, the landlord is responsible for making repairs, and they're responsible for doing it in a reasonable amount of time. They can't sit on it. They can't say, I'll address this a month from now, 2 months from now. They can't turn it back on the tenant. They can't get out of this obligation. So we see a lot of litigation around this, and some tips for tenants if they end up in this situation where the landlord's not making repairs. Couple of things. First of all, it's always good for the tenant to make those repair requests in writing. And I don't mean like a formal letter or certified mail. It doesn't have to be that. It could be a text. It could be an email. Like however you can keep a receipt of that complaint is really important. And it's not because North Carolina law requires that. Like the law does not say tenants have to make repair requests in writing. But if you end up in court and you're trying to use this as a defense or as a counterclaim, you have to prove it, right? So it's not a matter of like legally you have to do it, but you need to do it that way because you need to keep a record in case you end up in front of a judge. Another really powerful tool that tenants have, if you're making requests in writing and the landlord's ignoring it, there is a free service in Charlotte and in most counties in North Carolina, which is the code inspection process, right? So in Charlotte, you can dial 311, which is the government line. You can listen to the menu, ask for a housing code inspection. And if you do that, what will happen is that a city code inspector will come out to your home. It's free. It doesn't cost any money. They'll get there usually within a week or so. They'll look at the whole place. If they find any housing code violations, they'll make a report of that. They'll give one copy to the tenant. They'll give another copy to the landlord. And then they'll say, hey, landlord, you've got 30 days, whatever, to make these repairs. And if the landlord doesn't do it, the city can impose fines on the landlord. Sometimes they can even take the property away from the landlord. They can, condemn the property in some situations. And so even if the tenant doesn't have a lawyer or is, not wanting to get involved with the court process, they can use this free service and it'll put pressure, it'll light a fire under the landlord to get these repairs done. Because if they don't, there's some really severe consequences that can come along with that. One thing I hear a lot from my clients is like, I'll be like, man, you've been dealing with this situation for months. You haven't complained, like, why haven't you called the city or complained to them? Sometimes they don't know about it, but sometimes they say, well, I knew about it, but I'm scared because what if I complain and I call the city and my landlord, gets pissed off at me and then they file an eviction case against me, right? So they're worried about retaliation, right? There is a law in North Carolina that protects against that. And so as a general rule in North Carolina, retaliatory evictions are illegal. If you complain about repairs to your landlord, that is a protected act under the law. And if your landlord files an eviction case against you in retaliation for you complaining about repairs, that's illegal. And so if a tenant can prove that to a judge, that's a defense that can get the whole case thrown out. So just know that, know that if you're on the fence about should I complain, should I not complain, because you're worried about being retaliated against, there's a defense and that you can raise in that situation. And we raise that defense a lot, unfortunately. The other thing is, if the landlord keeps taking rent from a tenant, when the landlord knows there are things that need to be repaired and the landlord refusing to fix them, it can be a defense against an eviction case. It can also be a counterclaim. The landlord may owe you money because they have not repaired these things, right? If you've been paying your rent and you've been asking for these repairs and the landlord refuses to do it, the landlord could owe you money. And so we file counterclaims on that as well. And what the law basically says is that the landlord has an obligation to make these repairs. If they refuse to do it and they keep taking your rent, you're paying more for your home than it's worth, because the landlord has the duty to keep things fixed. And if they're not doing that, then they should owe you some money back. We call it rent abatement, like a rent credit that they owe you back in that situation. Another really important law in North Carolina, and this is also a federal law, it applies to the whole country, is the Fair Housing Act. And so it's against the law for a landlord to discriminate against a tenant for several different reasons, because of their race, color, religion, national origin, sex, familial status. Familial status means, landlords can't discriminate against you because you have kids. Believe it or not, that happens a lot, unfortunately. There are landlords that do not want to rent to families with children. It's awful, but like studies have borne out that that's a reality. But that's illegal under the law. Or a disability, and it can be a physical disability or a mental disability, right? And a disability just means that you have some, physical or mental disability that affects your day-to-day life. It's that broad of a definition. If a landlord discriminates against a tenant or refuses to make an accommodation for a tenant's disability, the tenant may have a defense or claim. So let's say a landlord refuses to rent to you because you have kids, right? That's illegal. Let's say a landlord refuses to rent to you because you have some kind of medical, it could be HIV or AIDS. If they don't want to rent to you because of that, that is absolutely illegal, right? And if they did that, and you could prove it, you could have a legal claim against that landlord. And these claims make money. I mean, this type of discrimination is really frowned upon by the law. And in that situation, the tenant may be able to get money or damages against the landlord for that illegal discrimination. There's also something under the Fair Housing Act called reasonable accommodation request. So an accommodation means that if you have a disability and you need an accommodation for that, as long as it's reasonable, the landlord should grant it under the law or should allow it. It doesn't have to be formal. That request can be written, it can be verbal. And if a landlord denies that request, that's against the law. The only way the landlord could deny it is if they can prove that it shows some undue financial burden or something like that. So I mean, the most classic example we talk about with this would be something like, maybe the landlord has a no pets policy. Maybe you need an emotional support animal and you have a doctor that signs off on that, right? Even if they have a no pets policy, if you can show the landlord, I understand you have that policy, but this is not a pet, this is a service animal. I have a doctor's note to prove it. The landlord has to let you have that animal. And if they do not, then you could have a claim against them. Yes. Mm-hmm.
Tenant would or the landlord would discriminate against the tenant, but it wouldn't be like explicitly, it's like, oh, it's not because you're Black, it's because XYZ. But what if you know that they're discriminating against, or you're getting discriminated against as a tenant? If you're not able to quote unquote prove it, are you SOL? Are you like out of options, or is there some sort of other recourse? Because I can see people being shady and being like, oh, I didn't discriminate against you because you're living with HIV. It's because of this other legal reason, or XYZ. I just didn't know if there was any leeway to defend if you're not able to actually prove with an email or a text or something that you were discriminated against.
So that's a really good question. And I will tell you that most landlords are not dumb enough to admit the fact that they're discriminating against somebody, right? So a lot of times, like, you may get the feeling that this landlord is doing this for this illegal reason. And it could be any of the things we talked about. You're living with HIV because you have some other type of disability. It could be because you've complained about repairs and that's why they want to kick you out, right? And so the question is, if they're not dumb, and sometimes they are dumb enough, you'd be surprised. Like sometimes landlords will say straight out, this is why I want you out. And we're like, we got you, right? But the question is, if they're not dumb enough to do that, but you have this feeling or some evidence at least, or a belief that that's happening, what resources are available to you? So a court would have to have some proof that it was based on discrimination. And so that can be hard to get if it's not obvious. There is a local resource for that. And what tenants can do if they believe that they are a victim of discrimination, they can file a complaint online with the U.S. Department of Housing and Urban Development, HUD. And if you file a HUD complaint online because you believe you've been a victim of discrimination, HUD will kick that case into Charlotte, and they'll assign it to a group in Charlotte called the Community Relations Commission, and they will assign an investigator to talk to the landlord, interview all the witnesses, do a really deep dive into the case to try to, ferret out or dig out the facts in the case. And so it can be overwhelming if you're a tenant and you think that you're a victim of discrimination, but you're not alone in that process. If you want to pursue it and try to get the, unearth the facts, then by filing a complaint with HUD, you can get some help with that. And the Community Relations Commission in Charlotte is great. I've used them with a lot of my clients, and they've been able to resolve a lot of cases and get some really good results for my clients on that. In addition to reasonable accommodation, modifications as well. If you have a medical condition or if you have a disability that requires you to modify the property itself, a classic example would be like, if you need, grab bars for the shower, but it could be anything. Landlord's required to do that too, as long as you can show the connection between why your disability and why you need, or your condition and why you need the modification. Usually the landlord has to allow it, but it's ultimately on the tenant to pay for it.
Why is that?
Well, that's, I don't know if that's, I don't like that policy either. I wish the landlord would have to pay for it, but that's just what the Fair Housing Act says, unfortunately. So that's the status of the law. And so if and I'm not sure exactly the policy reasons behind that, but the point is though, the landlord can't refuse to allow you to do it, right? So if you need to modify the property somehow to accommodate your health condition, the landlord usually doesn't have to pay for it, but they can't tell you no. They can't tell you that you're not allowed to make that change.
So hypothetically, if I move, can I take that with me? Can I take the grab bars with me? Because of the simple fact is, I'm putting grab bars in your apartment
Right.
building that you own. So if I'm having to pay for it, why can I take it with me when I leave?
That's a good question, and there's actually some law on that in North Carolina. And what it essentially says is that if you can install it and then you can remove it without causing any permanent damage to the property, then absolutely you can take it with you. If you install it in a way where it can't be removed without really damaging the property, it becomes something called a fixture. And under North Carolina law, if it's a fixture, you have to leave it there. And so if you're needing to modify a property, talk to whomever's helping you do that and make sure that once we install this, we can remove it. And if like a grab bar, if you can take it out, if you can patch the holes up and return it back to normal, then absolutely you can take it with you, and the landlord's not allowed to keep it in that situation. Some other laws that are important in North Carolina are unfair deceptive trade practices. So there are some consumer protection laws in North Carolina, and believe it or not, there's a law that says that if you're running a business, including being a landlord, you're not allowed to do unfair things. You're not allowed to deceive people, right? You're not allowed to act in a way that is not fair, right? And one thing that our courts have decided is that landlords are in commerce. They're providing a service. And one thing in particular, going back to repairs, is that if a landlord knows that repairs need to be made and they refuse to make them, and they keep asking for rent and keep collecting it, not only is that breaking the law because of the landlord's duty to make repairs, it's also an unfair trade practice. It's dirty, right? That's not good. It's not fair. It's deceptive. And why is that important? Because it makes the penalties for the landlord a lot more severe, right? So let's say you have a claim saying, my landlord, I had this cockroach infestation. I've been complaining about it for months. The landlord refused to fix it. So you could file a claim based on the repairs itself. And maybe the court decides that you're entitled to get $200 back for every month that you paid rent, right? You can also argue that's also an unfair trade practice. That $200 a month becomes $600 a month because the damages are tripled. We call it trebled. And so you can get even more than you paid back. You can get 3 times the amount back, right? And you can also ask for attorney's fees if you have an attorney in that situation. A lot of people don't know about this, right? And a lot of people suffer with landlords that don't make repairs. If you know about these laws and you know that you might be entitled to some rent credit back, it's not only the rent credit, you could get penalties against the landlord for that. And they can add up. We've had situations where we've got $20,000 to $50,000 worth of rent credit back for tenants due to these types of situations. And sometimes the rent credit is more than the rent that's owed, and sometimes the landlord has to pay the tenant in that situation. Every case is different and is individual, but these are really powerful protections that tenants can raise. Another thing that drives me crazy that we see all the time is landlords charging illegal fees. There are limits on the types of fees that landlords can charge against tenants. The most common, one we see is late fees. So a landlord can charge a late fee, that's legal, but they have to wait until the 6th day of the month to do it. And it also can't be more than either $15 or 5% of the rent, whichever is more. So they can always charge $15, but if they're going to go with the 5%, they can't do more than that. So if a landlord tries to charge a late fee before the 6th day of the month, or if they try to charge more than the 15 or the 5%, that's an illegal fee. Another thing that we see that's really common is landlords will just make up fees and charge them stuff the tenant never agreed to, like, oh, I'm charging you this administrative fee or this or that, but it's not in the lease. There's nothing in writing showing that the tenant ever agreed to it. And that's also unlawful. If you don't agree to a fee, and if it's not authorized otherwise under the law, the landlord shouldn't charge it. For tenants that are subsidized, so if subsidized meaning if you're a tenant and you get help paying your rent through some government agency like HUD or whomever, the 5% has to be based on your share of the rent. So if you're in Section 8, let's say like your portion of the rent is only $200 a month, and then HUD pays the other $800 or whatever. If the landlord is going to charge the 5%, they have to base it off of your portion, not the whole amount, right? So that's another really common mistake that we see. But what we see, so what? So what if your landlord charges an illegal fee to you? What remedy do you have? You can not only get the fees paid back, but there's another law that says every time the landlord does that and they break the law, that's an unfair debt collection practice. And what the law says is that for each time they do it, you can get a penalty against the landlord between $500 and $4,000 for each fee. And so we've seen situations where a landlord has been charging illegal fees over and over and over again. We had one case, we claimed $300,000 on that because it's been going on for years and 4 years or whatever, and it can add up. And so that's another really powerful tool that we will use to try to help tenants even the playing field and to try to come back and get some relief against the landlord. We've had situations where a tenant is $10,000 behind in the rent, but they've been charged 20 illegal fees. And by the time we get done, the landlord's like, I'll walk away if you walk away, right? In that situation. So it can be a really powerful tool to kind of level the playing field. So, I'm getting close to running out of time, but I wanted to talk, we talked about, some tenants' rights. We got about 15 minutes left. We talked about, some legal rights briefly, and I want to leave about 10 minutes for questions to make sure that we have that too. But I also want to talk about some resources that are available for tenants right now. And so one of the big ones is rental assistance. And so I'll tell you all, like, since COVID started, a lot of people have been out of work, they've been losing their jobs, they've been struggling financially. And the government is aware of that. And the federal government has earmarked a bunch of money to try to help tenants pay their rent. And it's made its way to Charlotte. And it's a lot of money, and there's still money available. The trick is that it takes time to process the applications. And so before I go into this, I just wanted to say, if you're a tenant or if you have a family or a friend that's a tenant and they're behind on their rent, the earlier they apply, the better. It usually takes at least about 2 weeks to process the application. But the amount of rent that's available for help is a lot. Like I've had individual clients where they've gotten up to $10,000, $15,000 worth of rental assistance to pay off their debt, and it's helped them get out of that situation. There's a couple of different organizations in Charlotte that provide this help. The one with the most money is rampclt.com. It's an organization that's called Dream Key, but they have this website, and if you're behind on your rent, you can go on this website, you can apply for rental assistance. They're going to ask you to upload a couple documents. Most of my clients, if they have a smartphone, they'll take a picture and they'll upload it that way. But it takes, an hour or so to apply. And if you're approved, you can get up to a year's worth of rent paid out of the rental assistance. And there's millions of dollars still available right now, right? And not only that, if you're less than a year behind, sometimes they'll not only pay the back rent that you owe, they'll pay rent into the future. I had one client, they paid all the back rent and they paid 3 months ahead for her in that situation, right? The unfortunate thing is a lot of tenants are not aware that this exists, right? So we see people getting evicted all the time, even though there's money available, because they're not aware that this resource is available, right? And with this too, you have to show, because this is money that came down from like the CARES Act, the American Rescue Plan, all this type of stuff. It's all COVID related. You have to show that there's some type of what they call like a COVID impact on your life. Like I was out of work because of COVID. I had to keep my kids home from school because of COVID, so I couldn't work. I had a death in the family related to this. And that's one requirement to get this assistance. I will tell you though, you have to, basically make a statement explaining why COVID has caused you to get behind. That's all that they ask for. You don't have to show receipts and stuff like that. You have to, you don't need to lie, but you have to make a statement and they'll take you on your word is what I'm saying. So this is a requirement for that rental assistance. Another one is, if you live in Mecklenburg County, you know about crisis assistance ministry. They've been around forever, right? They don't have all the federal dollars, but they still have their own funding. And so even if you don't have a COVID related reason why you're behind on your rent, crisis may still be able to help you out. The one thing is they don't have as much money as RAMP does, right? And again, apply early. The saddest thing that we see sometimes is that tenants will be behind. They'll be in eviction court. They've had some type of, really legitimate reason why they're behind on the rent. They apply for the rental assistance, but they're already so far along in the process that before the help gets there, it's too late, right? So if you have family or friends or whomever who need this help, don't wait until you get an eviction notice. Don't wait until you get court papers. Do it now, right? Because the earlier you do it, the better the chances are that help is going to get there in time. I wanted to talk about one other resource just briefly before we get to questions, but there is a rental subsidy program nationwide, and it's called HOPWA. It's called Housing Opportunities for People with AIDS and HIV. And there's a group in Charlotte that helps administer that money. It's called Carolina Cares Partnership. And they help provide vouchers for people who are low income and who have HIV or AIDS. And it's part of a holistic service. So that's not the only thing that they do. There's a lot of other services that they provide. But the rental assistance piece is a big part of what they do. And the reason why I think that is so important is because it's really, really hard to get into subsidized housing, right? If you're low income and you need help paying your rent, and let's not like, beat around the bush. The rents in Charlotte are insane, right? They're crazy. Like we see like uptown, like studio apartments going for like $1,300. It's ridiculous, right? So a lot of people need rental assistance, but it's really hard to get into subsidized housing. If you apply through the Housing Authority on the Section 8 wait list, if you apply for public housing or any of these other types, you're lucky to have your name come up in 5 years, 7 years, 10 years. It takes a really long time. This particular pool of money through HOPWA that the Carolina Cares Partnership offers, the wait list is much shorter. It's much, much shorter than that. It could be months to a year maybe, or if you're willing to relocate to a surrounding county, it can be even shorter than that. And so for people that that have HIV or AIDS and they're wanting to get help paying their rent, call Carolina Cares Partnership, talk to them. There's a lot of other services they can provide, but the rental assistance piece is really big and it's something where you can get help much sooner than people are having to go through the traditional subsidized housing methods to do that. So I'm going to open it up for questions. I do want to say again, my name is Isaac from Legal Aid. Our website is legalaidnc.org. And our, our helpline number is on there and everything like that. So if you know somebody that's being evicted, feel free to call us. We're happy to talk to them. It's free to apply. If you qualify, our services are free. And so we can, definitely help you out in that situation. But I'll stop now and just open it up for questions if anybody has any.
Sí, yo tengo una pregunta. Oh. Okay, great.
Like it was a what? I'm having a problem with a tenant that lives above me. It's like a little quad. It's like 2 apartments downstairs, 2 apartments upstairs. And since she has moved in, it's constantly noise. It's just constantly noise. She's banging, she's knocking, she's moving furniture. She hangs clothes out, her clothes goes in the driveway. I'm having to pick them up. I mean, it's just constantly something going on. I complained to my landlord back here about 4 months ago. And so my landlord goes up, speaks with her, comes down, tells me that, well, she pays rent, so she has the right to live the way she wants to live. I said, okay. So her thing is, so about 2 weeks later, I complained again. I said, it's just a lot of noise. I mean, this is going on 2 and 3 o'clock in the morning. I mean, she's just knocking like she's got, I call it marble. She just rolls across the floor, whatever she drops. And it's like a bowling ball. It's just bam, and it wakes me up and it startles me. And I'm telling the landlord, look, it scares me because I live by myself. And I think somebody's breaking in the back door. So she says, well, if you don't like it, and if you don't like the noise, because she, like I told you before, she has a right to live the way she wants to live because she pays rent, then you can move. And I'm saying, why should I have to move? I'm not the one causing the problem. I'm not the one breaking the lease.
Right.
So what do I do?
Well, so, and again, I can't give you any specific legal advice, but I can give you some information that I think might be helpful. So there is this concept in North Carolina law. The legal term it's really long. The implied covenant of quiet enjoyment is the term for that. And what that means essentially is that whenever a landlord rents an apartment or a home or whatever to a tenant, they're guaranteeing that they're going to allow that tenant to live there peacefully, right? And so that's a concept that goes back a couple hundred years. It's in our North Carolina, our cases and everything like that. But what it essentially means is that the landlord does have a duty to make sure that the tenants can be at peace at home, right? And not have any kind of undue harassment or things like that. So in that type of situation, if a tenant's complained about repeated noise disturbances and things like that, the landlord does have some legal obligation to try to make sure that the tenant is not being harassed or is not being disturbed wrongfully, right? A couple of things with that. So, I mean, technically, if the landlord keeps refusing to fix that issue, the tenant may have a claim against the landlord under that law. And so I've had clients in that same situation where we've sent a demand letter to the landlord and we've said, we have the right to live here peacefully. You have an obligation to make sure that we can do that. We've complained all these times about it. You haven't solved the problem. And so we may have some type of legal claim against you and you need to fix it, or we might pursue that against you, right? So that's one thing that will do the trick sometimes. The other important piece, though, one thing that caught my attention is you said the landlord tells you, well, why don't you move then, right? And we've even seen situations where like a tenant complains a lot about a neighbor making noise, or it could be anything. It could be other stuff too. I mean, maybe not just a neighbor. Maybe it's like the elevators, broken, or maybe the landlord's harassing you, right? Maybe the landlord's like calling you or coming over unannounced and stuff like that. And so the tenant complains enough to where the landlord decides, well, I'm going to evict you because you complain so much. When we were talking about retaliatory eviction, and we were talking about how it's illegal for a landlord to retaliate against you because you complained about repairs, it's not just complaints about repairs, it's complaints about any legal right that you have under the lease. And that includes things like complaining about noise disturbances and things like that too. So if your landlord ever got tired of you complaining and tried to evict you because they're tired of you complaining about these noise disturbances, that's probably illegal as well. And that could be a defense that you could use in an eviction court if it got there.
Well, suppose I keep complaining and she doesn't do anything about it.
Yes, I mean, that's a situation, again, like there is an obligation for the landlord to do something about it, right? But then the question becomes, if they don't do anything about it, what options do you have? That may be something where, again, technically you could file a claim against them for that, right? And that's something that we do help at Legal Aid. Some clients pursue that. It usually doesn't get to the point of us filing a lawsuit, but it may be something like we send a scary letter to the landlord to say, like, you're breaking the law and you need to fix this and stop. And usually that will resolve the process, but that's one path that a tenant can take in that situation. Mhm.
Let's say you're having to deal with some sort of issue with maybe a fellow tenant, or I live in an apartment complex and sometimes kids have been like skipping school and like loitering around, and they've requested, oh, if you see these kids, call the police. And I don't feel comfortable doing that. And I've noticed, even with like ride-alongs that I was like forced to do, like there have been situations where, there'll be tenant disputes or disputes between landlord-tenant and the police get involved. Are there other resources for, I guess, mediation that don't involve the police for landlord-tenant interactions?
Yeah, so when I was talking about, if you think you've been discriminated against, you can file a complaint with HUD and it'll go to the Community Relations Commission. The Community Relations Commission in Charlotte also has something called a landlord-tenant mediation program. And it's a program where they will offer free mediators. And they've been doing this for like 25 years or something like that. And so if it's a situation where tenants have a dispute, or there's a dispute involving landlords and maybe multiple tenants, and they want to try to get some type of resolution without getting the courts involved or without getting the police involved, that is a free service that the Community Relations Commission provides. The one thing with that, it has to be voluntary. So everybody involved has to agree that they want to meet, right, and mediate. But if they do, they will sit down in a room and they'll have a trained mediator that will go through the issues with everybody and try to get to a resolution. And one thing that I think is good is that so many people are being evicted right now that those mediators have started showing up to the courthouse just to be present on the day of eviction court. So they'll actually show up and be available. So I was in court, today's Saturday, I was in court yesterday, and there was a landlord and a tenant that were arguing about something, and like the tenant had already moved out. She just needed to get the rest of her property out, but they were having trouble figuring that out. And the landlord was trying to go forward with the eviction case, which would have put an eviction judgment on her record, which would have been bad, and all kinds of other bad stuff. And when the judge realized, is the only thing you guys can't agree on is like making arrangements to get the rest of the stuff out, they said, yeah. She said, go talk to the mediator, right? So those mediators are actually at the courthouse right now helping resolve these types of issues. And so that's another free resource that people can use.
So not a direct question from me, but it's actually coming from Janine, and she wanted to know if there is like a national source that people could look to for different states.
Yeah, there's a couple, as far as like landlord tenants rights go, Legal Aid in North Carolina, we're it pretty much. We've got we cover the whole state, and we've got a lot of litigators that help represent tenants. And I'll say one thing too, landlord tenant laws are different based on each state that you're in. So each state's laws are a little bit different, but there are federal laws that apply to everybody too. But there is a NHLP, the National Housing Law Project, NHLP. That's a federal group or not a federal group, it's a nonprofit, but they cover the whole country. And they are all about tenants' rights and educating tenants wherever you are about what your rights are. And there's a ton of good information on their website, NHLP. I think it's nhlp.org if I'm not mistaken. If not, you can Google it. But that group is good. If you have someone in a different state and they're looking for help on what their rights are, they can check that out. But they can also just look to whatever their local legal aid organization is. So there's there's a government corporation called the LSC, the Legal Services Corporation, and they fund the work that we do all across the country. So in every state, there is a group like us that can help.
Thank you, Isaac. Does anyone else have any questions? Any other questions? All right. Thank you.
Okay, I'm happy to be here. Y'all have a great day. It's great to talk to y'all.